Okay, Milan. I hope all of you are fine and happy this evening. And all about this presentation is with respect to punishment. And we have discussed a lot about all sorts of punishment except solitary confinement. Wherever you go, there will be theories on punishments or different kinds of punishments are talked by many people. But with regard to solitary confinement, I haven't seen anyone who talks about it. That is the main reason why I thought of making or taking up this topic for this evening in this program. And Milan and National Policy Forum, in association with Christ University, we are conducting this 3-day webinar on 3 different subjects. Today it is criminal law, tomorrow it is corporate law, and on day after it is constitutional law. So 3 different subjects, 3 different topics we are going to discuss with you. And Milan, can I start?
Sure. Sure. I think we have more than approximately 50 students join in. And students are still joining in, but I think, yeah, you can go ahead and start.
Okay, because it's already 6:15, I think.
Yeah, sure, please. Thank
okay,
you.
thank you. So all of us know that we are human beings. When we are human beings, we all have the right to enjoy our life, enjoy free movement, enjoy freedom of speech, enjoy whatever fundamental or human rights, whatever we have. But whether this fundamental or enjoyment on fundamental or human rights, is it absolute? And everybody knows that it is not absolute. It's based on restrictions, and that restriction is a quality restriction or qualitative restriction that is based on choice of the government. So no freedom is absolute. Reasonable restriction, we will say, but it is not reasonable restrictions. It is the restrictions of the ruling party or the government. That is what is the exact reasonable restriction, and that it's based on the policy of that particular government. And it varies from government to government, country to country, and there is no specified definition for this reasonable restriction is mentioned. But this freedom is not absolute, especially for a person who is convicted in a criminal case. So when a convict is going to the jail, then he has surrendered all his freedoms. So he will have only the basic necessary freedoms or rights alone he will be given. And even for a heinous crime who committed, or even a small, the person who has committed a small crime, also with respect to the freedom or the rights that he has to submit when he enters into a jail. But here the question is, who is going to be, or what is this solitary confinement? Solitary confinement is, solitary confinement is a kind of detainment in which, I hope the slides are visible.
Yes, sir.
Okay, thank you. Solitary confinement is a kind of detainment in which a prisoner is detached from any human contact for 22 to 24 hours per day, with a sentence going from days to decades. This is what is called solitary confinement. And these solitary confinements are there in all the countries in the world, irrespective of whether it is a capital country or a socialist country or a communist country, irrespective of whatever be the form of government, the solitary confinement is there in all the countries. And the most, to be frank, the most notoriously used form of punishment is in America. When it comes to Asian countries, the usage of solitary confinement is comparatively less when we compare it with Europe or China or Russia. So, according to US legislations, because in US the laws vary from state to state, so there is no codified national law with respect to solitary confinement is not there in the USA. So it's all state-wise local legislations. And according to them, what they do is the first 2 days in a week, it is 24 hours solitary confinement. In other 5 days, they will get 1 hour or maximum 2 hours. They will allow the detainee to go for exercises. And that exercises, we will think that it is an open ground. No, it is not an open ground. It is in a hall where they can run 20-25 feet and they can run around. That's all. Sorry. So there also, they are in a confinement where they cannot get an open air. And there will be guards who will be closely observing these people. But they are not allowed to talk even in that 2-hour period, because no other detainees will not be there. Only the solitary confined convict plus the guards. And sometimes even the guards will put chain on the confined and then will be allowed to go out in the sense to the open space or the open hall. And after 2 hours, they will be asked to get into their cage. The size of the cage normally varies from, or the normal size is 8 feet into 10 feet. Sometimes it is 7 feet to 9 feet. It's all depends on the which kind of prison you are in. But normally in India, where I have seen, the size of the solitary confined place is 8 feet into 10 feet. And normally it is fully covered with bricks. A small window will be given. And through that window, you can see the outside if it is open space. Otherwise, you will see the opposite rooms or cells wall alone. And they will not give you sufficient light. They will not provide a proper lights there. It's a very dim lights where you cannot have a read or to have a reading. And you will not be allowed to have a TV You will not be allowed to have a music system, nothing. And the food will be given through a cage, which can be pulled and pushed. And with regard to the toilet, they will give a portable toilet in that particular cell. So in short, the solitary confined cell is maximum is having 80 feet square feet size with a portable toilet, which we in the sense the detainee is using, and that it will be removed only once in a day. There is no flushing, no washing, nothing. And if you want to take bath, that bath time also will be reduced from the 2 hours that you get to get out of this confinement. That's it. And you should see the psychological imbalances that is going to happen when a person is alone in a semi-dark room. What all things he will be having in his mind. All those things we will be discussing later. And when we look at the history, I think that the researchers are telling it started 1780s with a good intention that isolation is a form of reformation whereby they will read the what is called the holy scripts, and they will be repenting themselves, and they will be spiritually reformed. They will have remorse, and then they will be a better citizens of the nation. That will be the thought in the initial stage when this solitary confinement was introduced in 18th century. But you know that ultimately what happened? It didn't have any reformation, but at the end, what happened is all the detainees became psychologically ill. And when they come out, they are not behaving as a human being. That is the reality about which we will be discussing at the end. And what says about this is, you might have seen about this solitary confinement in many movies, or might have read it in books. The basic human rights are denied. They will not get sufficient water to drink. They are denied the freedom of using the free air. They are denied to use sufficient light, and they are denied from the right to communicate with human beings. And after all, they are restricted to have a sanitary place to sleep. So these are the horrible situations which a solitary confined detainee is supposed to have. And when you look at the provisions in Indian Penal Code, solitary confinement can be awarded for not more than 14 days at a time, and the maximum time is 3 months. Yeah, this I already said it. And in 2016, President Barack Obama outlawed solitary confinement for juveniles in America. Okay. So in India, what is the rule is 14 days continuously, and maximum in a jail sentence, a convict can stay in a solitary confinement is 3 months. But the developed nations like America and many other European countries, or in the communist countries like Russia and China, the situation is not that. They once they are allowed to, or they are sentenced to go for solitary confinement at any time the authority wants. They can say that you are not allowed to come out of this solitary confinement. It goes even to years after years. There were a lot of instances, or if you search it in the YouTube, you will find a lot of victims telling that they were there for 25 years in a solitary confinement. The basic rights of a human is denied for 25 years in a solitary confinement is a big punishment. I will come back to Nepal history as well at the end. So, in this is an Indian case, Kishore Singh Ravinder Dev versus State of Rajasthan. And in that case, the Supreme Court of India has very elaborately discussed about solitary confinement, and at the end the Supreme Court said that it is a brutal type of incarceration. So and that is a fact. That is a fact. And there the Supreme Court also observed that solitary confinement inmates are completely isolated from their fellow inmates and separated from outside the world. And it is a drastic measure that should only be used in extreme circumstances of unimaginable brutality and atrocity. And you can see that according to the United Nations standard minimum rules for the treatment of prisoners, there it has been defined solitary confinement as the confinement of a prisoner for 22 hours or more a day without any human contact. When it comes to section 73 and 74 of Indian Penal Code, or that is which is still in existence in India, but from 1st July 2024 onwards, the IPC will be stopped working and Bharatiya Nyaya Sanhita will be coming into force. And as per that, sections 11 and 12 are the corresponding sections of solitary confinement and the procedure for solitary confinement. And along with the section 29 of the present act. These are the legislations which deals with solitary confinement in India. And section 73 or section 11 of Bharatiya Nyaya Sanhita reads as, whenever any person is convicted of an offense for which under the code has the power to sentence him to rigorous imprisonment in court, may by its sentence order that the offender shall be kept in solitary confinement for any portion or portions of the imprisonment to which he is sentenced, not exceeding 3 months in the all, according to the following scale, that is to say, a time not exceeding 1 month if the term of imprisonment shall not exceed 6 months, a time not exceeding 2 months if the term of imprisonment shall exceed 6 months and shall not exceed 1 year, a time not exceeding 3 months if the term of imprisonment shall exceed 1 year. Even if you are in a death sentence, the maximum time you can be in solitary confinement in India is 3 months. And that too within a continuous period of 14 days, not more than that. That is the law that is in prevalent and which is going to continue in India. And this legislation was passed by Britishers. But in British, this is not the system. There they can have solitary confinement to an unconditional term. There is no restriction as we have in India or we have in Nepal. But in the European countries or in the America or in China or in Russia, the limitation of the term of imprisonment, solitary imprisonment or confinement is not restricted. It is according to the policy of the government. But here in India as well as in Nepal, it is restricted by legislation. That is the beauty of our nations. Okay, so we are proud of it. And generally, when we look into why this solitary confinement is given, there are two reasons for this solitary confinement to be awarded. One is to discipline them. Second, if they are facing capital punishment. You know, the maximum punishment that a person can get in the world is capital punishment. And in 2-3 interviews, I had seen that the solitary confined persons who were telling that capital punishment was better than solitary confinement. In capital punishment, the treatment that the detent will get is far, far better than solitary confined prisoner. Capital punished or a person who is sentenced to capital punishment, he gets routine medical checkup. Every week, a doctor has to come and doctor has to check his health, his psychological health, not only physical, psychological health as well. They have to analyze. And the food has to be checked before giving to them. All these kinds of strict procedure is followed for a capital person who has been sentenced for capital punishment. But for a solitary confined prisoner, none of these things are applicable. Nobody is going to check his psychological health. Nobody is going to check his physical health. So neither psychologically nor physiologically he is not at all taken care by the guards or the wardens, whatever it is. So they do not know what discipline they are learning inside it or what they are doing it. So there are a lot of discrepancies or misuse of solitary confinement in all the countries at right now. In America, in Russia, in China, in European countries, what they do is, if under the name of terrorism, under the name of against the government, they are put them into jail, and later it is converted to solitary confinement. And that kind of brutality they are doing. But in Asian countries, we are not doing all that much brutality to the prisoners. Okay. Then it goes to certain cases. The first one is Sunil Bhadra versus Delhi administration. And this Sunil Bhadra versus Delhi administration is a case where, based on letter sent to a judge of the Supreme Court, has been taken up by them, and then they had taken up suo moto case, and that is Sunil Bhadra's case. And here the brutality of the jail authorities that has happened, not to Sunil Bhadra, but to another inmate in the prison in Delhi. And he is not in a position to even go for his primary requirements in the toilet. Because in the anus, the wardens has inserted some stick. Later it is found an iron rod with the rest. And it has become infection and he is suffering. And for that reasons, this Sunil Bhadra had sent a letter to the judge of a Supreme Court, and that has been taken as a public interest litigation, and it has come up with a beautiful judgment written by Justice V.R. Krishnaiyer. And the second, Sunil Bhadra versus Delhi administration, is also deals with the who are illegally cannot incarcerate any persons who are in jail. It's again a continuation of the first case. And in that case, the court very specifically said, and when the jail authorities or the government degrade the prisoner, it physically as well as psychologically causes a lot of trauma in them, and they are not supposed to be in such a state. And the right to move, right to mingle with the public and be in the company of other prisoners are also unjustified. That is the ruling in the Sunil Bhadra 2 case. So if that is the mandate, or if that is the precedent, then solitary confinement is illegal. That's what I want to tell you. Because the court is very particular about two terminologies, that is, whatever causes the bodily and mental suffering to individuals who are subjected to be in jail is a degrading, it has a degrading effect. And second, restricting the right to move, mingle, and to be in the company of other prisoners is unjustified. And further, it says it is a violation of Article 21, that is the right to life. So it is unjustifiable. If that is the case, why we are having solitary confinement? That's a big question. But still, even though the court has mentioned all these things and given these kinds of judgments, still we do have solitary confinement in all the countries. Then the another case that comes is Unikrishnan versus state of Andhra Pradesh. And there the Supreme Court has again said about the solitary confinement. And there the court said the right against solitary confinement is one of the constitutional rights protected by Article 21, right to life. In this case, the Supreme Court declared that the right against solitary confinement is protected under Article 21 of the Constitution of India. That is the right to life. But still, we have that. Then again, the case what I said, the previous slide, that is Kishore Singh Ravinder Dev versus State of Rajasthan. Then the next case comes to Union of India versus Dharampal. And that is an interesting case where the Supreme Court observed he is a death convict and spent in jail more than 25 years, and 18 of which were spent in solitary confinement. When I showed in the previous slide, there are two situations where a solitary confinement is given. One is to have discipline. Second is if the convict is given death sentence. But here, as far as Dharampal is concerned, he is very specifically, Indian Penal Code says, under section 73 or under section 11 of the new legislation that is going to be effective from 1st July, there it says the maximum sentence. There it never ever distinguish whether it is a 1 year or a 10-year or a life imprisonment or a capital punishment. The maximum period that can be in solitary confinement is 3 months. Very specific. And again, in the beginning, the same section says at a time only 14 days. But here, as far as Dharampal is concerned, he was in jail for 25 years, out of which 18 years he was in solitary confinement. And that too not in one jail, but in various jails. And then the president considered his mercy petition for reducing his sentence from death penalty to life imprisonment or a remission. And there they said it was illegal and it is an additional punishment that is given to him, which is not sentenced by the court. So jail authorities do not have any power to include or add any other form of punishment other than what the court is given to them. So in such way, if we analyze that situation, it is an additional punishment or additional torture given by the jail authorities to Dharampal, and hence the president has freed him from jail. Another case is Vadeshwaran versus State of Tamil Nadu. It is a 1983 case, which is very interesting. And this is a case where eight years this Vadeshwaran was in solitary confinement, and because he was also sentenced to death. And but later it was taken off. Now the last two cases are from Nepal, and the first one, I hope most of you, anybody has heard about this Bahadur Bagale versus Nepal? Anybody? Can you say anything on this case? If anybody is aware. Hello? Anybody has heard about this case? No answer.
Yes, sir, I have heard about this case. It's about the arbitrary detention and torture.
Okay, can you tell me anything about that facts of the case? Anybody?
Actually, I don't have the facts. I have not remembered it, but it was the case was held in between 2002, during the time of the then monarchy.
Okay. Yeah. This is a case that has happened in between 2002 and 2006. And this Bahadur was a police constable, and his senior officials were not in good terms with this particular police constable, because he was always thinking about what is called the right way, because he was against the corruption. So the police authorities were not ready to agree with whatever this Bahadur was or Bagle was telling. So, and actually the problem that happened is with respect to an allegation of stolen gold. And the superior asked him to confess, but he didn't confess. He said he has not taken the gold. So, being angry with that part, the authorities took him to jail and started deprivation of liberty. And he was not informed the reasons why he is arrested, or any of his friends or family people were informed about the charges that were charged against this Bagle. And the procedure prescribed under Nepalese legislation to carry out an arrest and detain a person was not at all respected, even though he was a police officer. And he was kept in the custody room in Kathmandu, near Kathmandu, and he was handcuffed and forced to wear a hood. He was placed in solitary confinement and had no contact. As since he is in solitary confinement, he had no contact with the outside world. He was not provided with food or water, and the conditions of the detention were inhuman. The room was dark and dirty, with bugs and with no toilet. In other countries, when I said there were portable toilets were there, but when it came to Bagle, there was no toilet at all in the solitary confinement. And often in the nights he was subjected for repeated interrogations for a quite long, and thinking the as far as the version of the prosecution, all these long questioning in the midnights or the late nights happened with the aim of obtaining information of the alleged stolen gold. And whenever there was an interrogation, he was physically tortured and subjected to severe ill treatment. Abuses were committed outside the police premises too. And police were always used to make search in his house, and they had tortured especially his wife and his daughter. All these things, and verbally as well as sexually threatened to death. And what happened is later he was freed, but with the threat that we will be following you, we will be observing you. And they tried to intimidate him, and then at the end, he filed a complaint before the domestic judicial bodies, and nothing happened. In fact, the threat that were given by the police intensified just because of the complaint that he had given in the court. And then nothing happened. So he filed a complaint before the National Human Rights Commission. Commission also didn't take any action. And the reason why the commission didn't take the action is that it is a sub judice. You know what is sub judice? There is already a matter is pending before the domestic court. So we cannot take the action. That was the stand taken by the Human Rights Commission. So in 2004, the district court, that is the domestic court, rejected his complaint, holding that whatever claims he has made, he couldn't prove it. And there was no evidence of his torture as per the Nepalese legislation. And he appealed, but appellate court also upheld the decision of the lower court, that is the district court. And he filed again to the Supreme Court, but Supreme Court also upheld the rulings of the lower courts. Now what happened is, in 2006, he tried to resign from the police, the department, and applied for retirement, which triggered the authorities, the threats, pressures to withdraw the previous complaints. And purposefully, he was tortured, beaten, and asked to stay in inhuman conditions, and they were abused him with the filthy languages. And this time again he approached the Supreme Court, and then they realized that something is wrong, and his arrest and detentions are arbitrary. And just because of the benefit of doubts, according to them, he was ordered to release. But the fact is, did not pronounce itself as an alleged torture or ill treatment. And in the district court, they also recognized it is a torture, but didn't take any action against these superior police officers. And the victim, that is Bagle, never received any compensation even. And because of all these tortures, all these issues, psychologically he became depressed, anxiety, paranoia, and personality disorder. All these things happened. As far as solitary confinement is concerned, these are the psychological impacts that happens on a normal human being, a common human being. Apart from that, they will be having physical self-inflicted wound. That is apart from this psychological trauma that they are undergoing. And in December 2015, Bagle brought his case before United Nations Human Rights Committee, and he alleged that there was a violation of Article 2, 7, 9, 10, and 17 of UDHR and ICCPR, to which Nepal is also a party. And in November 2020, HRC sided with the trial and Bagle and recognized that Nepal had violated its international obligations and should take steps to prevent the occurrence of similar violations in future. Plus, they said Nepal should ensure that its legislation effectively criminalizes torture and provides for appropriate sanctions and remedies. And right now, it is before the domestic authorities to enforce the HRC's recommendations. And still, we do not know when Bagle will get the true justice. That is Bagle's case. The last case is, you might be knowing, Charles Shobaraj. He was in jail in India as well. And when he got released from India he came to Nepal, and the Nepal government also arrested and put him in jail. And actually, this Charles Shobaraj, he was okay, all questions I will be answering at the end. And he was a French national. And there, what happened is he also had a lot of issues with respect to this solitary confinement and all other aspects. And he was arrested, I think, to my belief, he was arrested in 2005. Okay. So this is also another case, because I was told that the time is almost up. So I am just concluding it. So this is also another case from Nepal, that is Charles Shobaraj, and he is a foreigner as well, because he is a French national who committed a lot of murders and rapes in India as well as in Nepal. But even whatever be the crime that they are committed or they have committed, that's not the thing, but the violation of the rights of the the rights, whatever they have, whether it is fundamental rights or whether it is what is called the human rights, whatever be the rights, which are very essential for the human beings to survive in this world, has to be upheld. And in that sense, solitary confinement is not a civilized form of punishment that can continue any longer in this 21st century. That's it. And one question has come from Niloy. And the question is, in addition to this question, sir, has there been any survey by any Indian or foreign institution on how solitary confinement is being illegally inflicted upon detainees? There are a lot of studies has been conducted by a lot of NGOs and even United Nations in these aspects. But what happens is that whatever be the reviews they have given or the reports, whatever they had given, does not have any legal mandate. So since there is no legal mandate as we expect as a domestic legislation, it doesn't make any sense. So that is the reality with respect to. Any other questions you have? with respect